Recording is now in progress, as you've heard. I am Cécile Deniard. I am one of the French representatives of CEATL, the French Association of Literary Translators in France. So one of the representatives to CEATL, the European Federation of Literary Translators Association. I will be hosting this webinar with the help of Rafal and Hilde, who will monitor the chat room to voice your comments and questions. Also, Simina will be with us at some point, Simina from Romania, to tell us about the Romanian initiative around the dissemination of the survey. And also Andreas is with us and will draft a report of the webinar after. Well, thank you so much for your attendance. Some 23 people from 23 countries expressed an interest in this webinar. Either they are with us today or they want to get the link at a later stage. So, and it was at the last counting something between 150 and 200 people actually answered our invitation for registration. So that's an overwhelming response, and thank you very much. A large attendance from Italy, but that is no surprise because we know how good they are at motivating and mobilizing members. We have among us lawyers and legal counsels of our associations, a number of board members from our associations, also individual members of the associations, and not a few students and would-be translator. So a very mixed audience all in all. So I'll try to keep everyone on board and give something to chew on for everyone. The outline of the webinar will go as follows. Because this is such a mixed audience, I'll start with a very brief presentation of CEATL and the Authors' Right Working Group, and then a reminder about what is the DSM directive, because I refer to that European text of law repeatedly. So I'm sorry for those of you for whom it is cold news, but we need everyone to be able to follow that. Then we'll proceed with the actual presentation of the result of the survey in 5 parts. And between each part, I will invite Rafael and Hilde to voice your comments and questions on the maps. So please feel free to write in the chat. Then there will be a proper question time with some questions that were put to us at the registration stage. And more that might have cropped up in the chat section. Then a second part about disseminating the survey and using for lobbying purposes. I'll talk briefly about the Authors' Rights Working Group action at the European level, and Simina will talk about the Romanian initiative. Then there will be an open floor time. So if you are eager to voice yourself a comment or question, we will open the mic at that point, and then I'll conclude. So this was the outline. We expect this webinar to last anywhere between 1.5 hours and 2 hours, probably less than 2 hours, depending on our being talkative or not. Okay, I think I'm through with this quick introduction. Just a word, yeah, we had a registration from a publisher saying he wanted to know about good practices, so he's most welcome, of course. And now to a brief presentation of CEATL for those of you who might not know that this is the federation as I said, of European Association for Literary Translators. It was created in 1983, so that would be our 30th anniversary. It was founded by 10 members at the time, but it now has more than 30 member associations in 28 countries, representing some 10,000 individual translators. Again, for those of you who may not be familiar with these notions, we consider literary translation any work that is published by the publishing industry. There is no value judgment under that. It's anything from Shakespeare to a cookbook. CEATL itself has two sets of aims. One is internal. We gather information on the situation of literary translation and translators in the member countries. We share experiences and examples of best practices. And on the external front, we defend the interest of literary translators at the European level. So with the European Commission, Parliament, we network with fellow federations, as I will mention later on. We work year-long with now digital devices and meet one time a year. We have, of course, a board. I don't know if anyone can see, but I see now Lara in the middle of my screen. Lara from Croatia is our General Secretary. Our president is Sean Whiteside from England, from the UK, because Brexit is nothing to us. And other members of the board might be here. Michael from Spain, Valerie from France, Justina from Poland, and Francesca from Italy. We work within 5 working groups: best practices, training and education, visibility, working conditions, and last but not least for today, authors' rights. The authors' rights working group has 8 members from all over Europe. Our aim is to improve the working conditions of translators from a legal point of view, that is intellectual property law, fair contracts, codes of good practices. So our main issues these last few years have been monitoring the new European Directive on Copyright, which I will comment on just after, establishing guidelines for fair contracts. That's a document that is now published on our website, and I will also refer you to that document on several occasions. And mapping and monitoring the legal situation of literary translators in our member states. So, and this is precisely the purpose of the survey I will present to you. So before getting to it, a few words on the so-called DSM directive. It's a European directive that was voted in April 2019. DSM stands for Digital Single Market Directive, because initially the purpose of the European Commission was to create a unified market for digital works of art. At the end of the day, the final text contains provisions that actually apply to all the book industry and to all types of books, and not only digital. At the beginning of the process, there was great fear among rights holders, authors, creators, that the directive would jeopardize our rights and means of living. But after a long process of lobbying and discussion, the directive recognizes that authors and performers tend to be in a weaker contractual position, and hence they need protection. So the European Union sets minimal standards to balance the contractual relationship, and so that authors may get fairer conditions as to their remuneration and the exploitation of their work. In particular, Article 18 to 83 aim at empowering authors. And I would like now to share my screen. Okay, here we go. So this is just a slide with those articles that are of utmost importance for us in the directive. It's entitled 4, Chapter 3, Fair Remuneration in Exploitation Contracts of Author and Performers. So Article 18 sets the principle of appropriate and proportionate remuneration, both words being very important. So in the article and recitals, you will read that lump sum payments should not be the rule, and that the right to use collective bargaining to get fair, appropriate remuneration is recognized. So the argument that collective agreements would be illegal and an infringement of European or national rules of competition should no longer be used to refuse collective discussions on remuneration. Then there is the transparency obligation that is put forward by the directive in Article 19. The directive says that without relevant information, it is impossible for authors to assess the economic value of their rights. So the information provided should include all modes of exploitation and all revenues generated worldwide. It should be delivered at least once a year, and it should not be limited to authors receiving royalties. Every translator, including those only receiving lump sums, should get this information. Here again, the directive strongly encourages all stakeholders to work out agreements on transparency through collective bargaining. The third important provision for us is Article 19 and the idea that there should be a contract. Oops. Okay, thank you. Can you mute Lena? Raphael, I think it was. She seems to be underwater. So Article 20 is about a contract adjustment mechanism in case the initial remuneration was disproportionately low at the beginning. Note that you can know if the initial remuneration was disproportionately low only when the transparency obligation is fulfilled, including in case of a lump sum payment. The last two ones, Article 21 about an alternative dispute resolution procedure. This only applies to the transparency obligation.
Okay. Is this a British term, recital?
Okay, sorry. Yeah, recital is the legal term for the text at the beginning of the directive. It's the reasons that are behind the article. So they should be considered as a way to interpret the articles proper. Is that I'm looking for a synonym there. I'll find it. Well, Article 21 this low threshold mechanism for dispute resolution needs to be put into national law to resolve dispute around the transparency obligation and contract adjustment mechanism. So it's interesting in that it should force national states to create a mechanism whereby stakeholders, that is the association of authors and the associations of publishers, should reach agreements. And the last interesting provision for us is the right of revocation, especially when a work is no longer in exploitation, is out of commerce. the authors should be able to recoup their rights. So yeah, if there are a few quick questions on that, now is the moment before I proceed with the survey itself. Was my answer clear enough about the provision, the recital? Yes, no, so I proceed. With okay. Well, I seem to have closed the survey, but it's somewhere near. Okay.
Well, while you're looking for that, a
Yes.
recital in the OED
Yeah.
is part of a document that explains its purpose and gives other facts pertinent to the case.
Thank you very much. Okay, do you see the first slide of the survey? Yes?
Yes, we can see it.
Thank you. So this survey was conducted between May and July 2021. We had 27 respondents representing, as I said, some 10,000 literary translators, with only one person per country. The principle that was that the said answer was drafted by the most knowledgeable person or persons. Some associations worked in groups. So the most knowledgeable person on legal issues in each association. So as the case might be, it might be the legal counsel or board members or others. So when we have percentages, it corresponds to a proportion of countries, not individual translators. The survey was divided into 3 parts and 69 questions, so that was a big one. And I know a number of individual respondents are here. Thank you again for taking this long survey, and thank you for your very useful comments. So the first part was about the legal and contractual situation in each country, and this is the part I'm going to comment on today. And it was the bulk of the survey. The second part dealt with our association's legal resources and actions, like what staff our association have to pursue their legal aims, what kind of legal help they provide their members, like recommended fees, model contracts, workshops, lectures, contract vetting, help for dispute resolution, etc. Also, what type of action they're able to take in terms of negotiating with publishers, networking with other translators, writers, organizations, lobbying with public authorities, etc. So the second part of the survey I will not deal with today, but it is very much on our agenda to finalize the analysis for the next AGM, and we will come back to you with more on this. And the third part was about emerging issues like streaming services, self-publishing, and machine translation. In the questions written at the time of the registration, somebody asked about artificial intelligence, which of course has something to do with machine translation. Interestingly, at the time of our survey, very few associations mentioned problems around authors' rights regarding machine translation. very few publishers at the time, we're talking 1.5 years ago, were considering using artificial intelligence. Now, of course, we know this is probably changing rapidly. So these two I will not deal with today, but it's very much on the working group agenda. So the presentation will drive through 5 sections. First, the legal framework, then the scope and duration of the licensing of rights, the respect of our moral rights, remuneration, and transparency. So the first one will be the longer one, so do not fret if it seems long to you. Types of contracts, legal framework, negotiation. So to start with the beginning, signing a contract. This is the beginning of our guidelines for fair translation contracts. You need to have a contract. You need to be able to negotiate it, ideally before starting the work. So, and it needs to be in written form. It's good news that in most countries, formal contract is a well-established practice. It's a necessity for the license or transfer of rights to be valid for the publisher's own sake, hence the high rate of almost always or most of the times answers. However, respondents also underlined that with the allotted time for translations getting shorter and due to bureaucratic slowness, a fair and growing number of translators are forced to start working before signing a contract, which also makes negotiations more complicated. And it is to be noted that the answer most of the time leaves room for a significant proportion of translation done without a contract, as seems to be the case, for instance, in Spain, where as close as 30% of translations are done without a contract, according to white paper published in 2010 and 2015. In the vast majority of cases, the contract is signed with the publisher itself, which again, it's fairly good news, as this is always to be recommended to sign directly with the publisher, if only for the sake of accountability and transparency. There exists, though, a number of translation agencies for certain segments of the market, like coffee table books or mangas. However, at this stage and through this survey, no bigger trend is perceptible. Direct contractual relationship between translator and publisher is the norm. I come now to a map that needs a little bit of explaining. So it's about those countries where we have typical or standard contracts in the countries. It's actually not the majority of countries where you have either typical contract or standard contract. Definition: a typical or nominate contract is a contract whose content and form is very regulated by statute, by the law, and which henceforth has a special designation in the law. That's the case in France with the contrat d'édition, or in Italy with the contratto di edizione. So it's a pretty strict normative framework. Some force must be respected and compulsory provision must be present. There is still, of course, a level of contractual freedom. We still have to negotiate remuneration and schedule, but the framework, legal framework, is pretty strong. For the purpose of that survey, we defined standard contract as a contract agreed on by the association most representative of literary translators, and the association representing the publishers. I'm not sure if my sentence is very clear there. You'll make me repeat if it did not make sense. In those countries in green, in Norway, Sweden,
I don't think we're gonna go out. In this
Don't go out.
Does it start raining?
It is raining.
I'm sorry, Rafael. I heard something, but I don't know.
Yeah,
if
I muted.
it's okay.
If something like that comes up, I just make sure to mute.
Okay,
Go on.
thank you very much. So yeah, in Austria, Germany, the Netherlands, Sweden, Norway, Iceland, the biggest publishers syndicate association has signed an agreement with the biggest translator associations or writers association, and they have an agreement on a standard contract. By contrast with those countries where we only, if I may say, have a model contract that is put forward by our associations. That is a very great number of countries. So reading of this map is as follows. Countries in green offer a model contract. I mean, the associations of literary translators in these countries offer a model contract that may or may not be endorsed by individual publishers or smaller groups of publishers. Countries in blue offer a code of good practice, like those might be text precising, good pricing, good practices about the editorial process, for instance, how to best respect the moral rights of the translator, how to promote the work in partnership with the translator, that sort of things. And countries in violet, the association offer both a model contract and a code of good practice. So our associations actually make a very good job of offering text of reference. A very colorful one about negotiating one's contract. I confess this is one of the maps I'm not very happy with. And that is not very easy to make sense of, because, well, the situation is very contrasted, but it's very intricate, because reasons not to negotiate a contract go from finding the proposed contract satisfying to the fact that the translator lacks the knowledge to raise the negotiating points, or simply feels he has a weak bargaining position or doesn't have the idea. So this is one question, the negotiation, that we need, we feel that we need to go back to when we analyze the second part of the survey, and we discuss with the associations the best strategy to motivate our members into discussing the terms of their contracts. However, that is interesting. We ask our member associations what translator would negotiate when they do. And unsurprisingly, probably, economic gain is on top of the issues that a translator try to negotiate, whether it is the basic fee or the percentage of royalties. This is followed by the schedule and payment terms, so very practical questions, while perhaps more abstract items like compliance with the national law, model contracts, or code of good practice, or scope of the license get around 50% of answers. Perhaps also this is due to the fact, as we'll see, for instance, moral rights are rarely discussed, because probably in the first place they are okay in the contract, as we will see. We can, if we compare the points raised by the translators to the points where they think they will get results, it's interesting to note that translators expect the publishers to be comparatively unwilling to discuss the scope of the license, good practice, and remuneration. On the other hand, discussing the schedule is deemed more likely to to bring results. Well, I'm at the end of the first section. Raphael, do we have questions on those?
Well, the chat has been silent, so if anyone does have
Oh,
questions
okay.
at this point, to the first part of the presentation, this would be the moment.
I don't believe I'm being that clear. So please do not hesitate to write down, to ask me to repeat or clarify those parts where I've been blurry. So I come now to the scope and duration of the licensing of rights. The exact framing of the question was, is the scope of the licensing usually detailed, each license right being mentioned in the contract? And so, yes, in a very large majority of countries, the scope is detailed. But Poland in that regard is rather typical. So Raphael, I'll quote you on this. The law requires every field of use to be mentioned explicitly in the contract. In practice, it usually results in a long list of fields of use, covering all possible areas entered by default into every contract, generally non-negotiable. I believe most countries will recognize their own situation. So yes, it's in green, and it's good that it's detailed, this licensing, but in truth, it's very wide. Other questions showed us that the license usually include ebooks and audiobook, and it's very wide and take it or leave it. And in those countries marked in red, contracts will contain sweeping, all-inclusive formulas, like in Denmark, and I'm quoting Morten on this. I don't know if he registered, Morten is our former president. I don't know if he is actually in the room, but he said, I quote, "It is usually all-inclusive with terms like any known or unknown use now and in all eternity." So this is worse, admittedly, than a detailed license. But all in all, the situation is everywhere the same, that the license is very large on the take it or leave it basis. Now, this map was one of the most illuminating for me. We wanted to know for how long the license was granted by translators to the publishers. And the picture, as you can see, very clearly defines two main groups of countries. In orange, those countries where the rights is usually licensed by contracts for the duration of the intellectual property. I insist this is by contract. There's nothing in the law that says it needs to be. The duration of the intellectual property is 70 years after the death of the author or the translator, in our case. That is for the case for 11 countries. In the blue countries, the license is usually limited in time, usually 5 to 10 years, up to 10 or 15 years for Spain, and 20 years for Italy. So that is the case in 15 countries. Well, I'm not sure, even the publishers are a very clear view about that at that point, or other writers. It was a discovery for me, this twofold panorama. It's good to know. It's always good to know more than the others. I mean, talking from France, I know publishers take it for granted that the rights will be licensed forever. It's although it can always be negotiated on an individual basis, but with little chance of success, admittedly. To be honest too, I am not sure that one situation is really better than the other. Because as we will see later on, those countries where the license is usually limited in time are also the countries where translators more rarely get royalties and transparency. So it's debatable whether it's better to have limited in time licenses or theoretically unlimited licenses, but royalties, transparency, and the possibility to get your rights back when the work gets unexploited. And these things usually go together, so you need to have the big picture to make a decision about that. Well, talking about the reversion right, the reversion right should become the rule with the implementation of the directive. That is, in a majority of countries right now, contracts usually don't contain a clause of reversion to the translation if and when the publisher loses the right on the original work or for lack of exploitation. Yet, it is important to note that even in those countries that are in those countries, that are now in red, like Croatia, Denmark, Italy, or Romania, the law itself gives all authors and therefore translators the right to terminate the contract in case of non-use of the work. So again, they're in red, but the situation is maybe not so dire. So this is also one issue that we will closely monitor along with the implementation of the directive. Okay, so I'm now at the end of the second section. Has the chat woken up?
No questions?
Okay, well, we are going to be very fast on this. Okay, so I come now to the moral rights. So if we have students among us, just a quick reminder that the Berne Convention grants author moral rights. The most important for us being the right of attribution, that is the right to be recognized as the author of our works, and the right of integrity, that is no changes shall be made without our knowledge or approval. So the contract must provide for an editing and proofreading process that respects the translator's legal right to be informed of and be able to verify any change made to the translation. So as you can see, those maps are pretty green. In 3 countries out of 4, the translator's right to the integrity of their work is usually recognized in the contracts and generally respected, if I believe the comments made by the respondents. Though respondents also underline that this can depend on the professionalism and goodwill of the publisher. And also, it is very important that the individual translator plays an active role in making those rights respected in reality. For instance, the translator should ask to see and approve the modifications as well as the final text with enough time to do so. A few countries, such as Italy, have registered real progress on that front in the last few years. So yes, on the whole, a green situation in many countries, so that I think it should encourage others where the situation is perhaps less rosy or more reddish. It's also a good thing when a revision process is provided for in the contract in case the publisher is not satisfied with the first version of the translation delivered by the translator. In 3/4 of countries, there is indeed such a provision in the contracts. Yet several countries in the comments underlined that it's actually a rare occurrence, and I'll quote Finland on this, that it is almost unheard of that the publisher should reject the translation because of quality issues. So I take it that we are very good professionals and we should get our money for it. A more red map this time about conciliatory procedures. We are now at the stage of a dispute. A large majority of countries lack such procedures. In France, Spain, or Switzerland, there is indeed a mediation system between translators and publishers associations, though in France it usually doesn't find its way into the contract, so that's why it's in red. But there is some level of cooperation between our associations in case of dispute. Again, as I said, there should be progress on that front following the implementation of the directive. Naming the translator in the published book, that is an all blue, could be all green map. All countries answered that the name of the translator is usually mentioned on the title page. This is coherent with the findings of another survey that was published by the Working Conditions Working Group. I'll talk about it briefly later, but they asked directly individual authors, individual translators in the countries about it, and they also found that the name of the translator is usually mentioned in the book and usually on the title page. Mentioning it in the front of on the front cover is a growing trend in many countries, and is of course considered as a best practice to be promoted.
May I ask, Ireland and Bosnia didn't take part in the survey, is that right? Because they are not in blue here.
Ireland didn't wish to take part because ETA, I hope not making a mistake here. Our member association has a few members working in the field of literary translation, so they felt they could not answer for themselves, and then they would not associate with the answers given by the United Kingdom, though
Okay.
Translators from living in Ireland would probably work with British publishers. And you mentioned Bosnia. We don't have a Bosniak member.
Nor do we have Greek member.
Nor do we have Greek.
Okay.
Lara is in there. We've been working on that for a long time.
I remember.
Yeah, I believe there are several associations. We really want to get a member back, but no, all active members, active member associations have responded to the
Yes. Okay.
to the survey. A mixed picture again for the naming of the translator on all publicity material. catalog and media announcements and so forth. So we all know this is a daily battle for our associations. This is an item that can typically feature within codes of good practices, whether they be co-signed or not with publishers. But still, so daily battle everywhere, but still some countries seems to be doing better than others. So good for Finland and Lithuania. We need to see what they are doing well, so we can all copy that. Okay, any other question before I go forth with the very important remuneration subject?
Not in the chat room, no.
Okay. So I'll start the remuneration section with two slides that I found really preoccupying, because they are in such dire contrast with what we feel would be right and what is said in our guidelines for fair translation contracts. In our guidelines, you will read that on signing the contract, the translator should receive an advance payment of at least 1/3 of the fee, and that the remainder shall be paid no later than 60 days after the delivery, and that payment on publication is unacceptable. Now, what we find is that actually in 2/3 of countries, no advance is usually given on signing the contract. Of course, in some countries where it's not common practice, it can still be negotiated on an individual basis. Respondents from Finland, Slovenia, Spain, Lithuania said so, but still it's not common practice. In those countries where advance is common practice, it represents 1/4 to 1/2 of the initial fee. So that is in line with our recommendations. And to compound the problem, in half the countries, the initial fee is usually not completely paid after 60 days after the delivery. And in the comments, I read frightening things like in Macedonia, for translations funded by the ministry, translators have been known to wait for a long time, even years. Also, for the advance from Slovakia, I have in non-commercial publishing, i.e. publicly supported publishers, an advance is rare. So I find it very strange that in those cases, publicly funded translation would actually lead to more unfair payment terms for the translator. Also, I see in Iceland, it's also common practice that the initial fee, the remainder of the initial fee will be paid after publication, and so forth. So, looking at the maps and reading the comments, I feel this is really, those payment terms are really a great part of the financial insecurity that literary translators suffer from in actually a majority of countries. And apart from the rates, I think we really need to work on that, because how can you negotiate when you don't have money in your pocket in the first place? I mean, again, it came to me as a surprise, and I think it's something to really put forward, because it's very unfair for translators to be working for weeks and months for nothing, literally. Then about royalties. We can see that in 16 countries, the majority of them in the north and east, also Italy, translators don't receive royalties even in case of a bestseller. And when they do, royalties are paid after a specified time in Norway, after a specified number of copies sold, or after the initial fee has been compensated. Now, I want to comment somewhat on this map. The lack of royalties, that is, translator get a lump sum payment, potentially goes against the principle of proportionality set forth in the DSM directive, and it should logically be remedied as part of its implementation. Of course, this should be done without renouncing decent basic fee, especially as in those countries where there are royalties, or royalties are provided for in the contract. The percentages are very low, for instance, 1 or 2% of the book price, or thresholds are very high, like in terms of the number of copies sold. So that in actual fact, translators rarely get anything on top of the basic fee. So, of course, nobody should renounce their bread and butter and exchange that for a lottery with the royalties. However, translators should be able to make a fair revenue from their work and benefit from it when the book is a success. Especially, and that's the other point I want to make, apart from the potential economic gain of having royalties, and it can be very real in those rare cases where the book is actually a bestseller. But apart from that, not giving royalties to a translator is a way for the publisher to buy him out or her out of the relationship. In that case, usually the translator won't be informed of the exploitation, won't get any transparency. These things go together. So symbolically, also, it's important to get royalties, to get the whole package: royalties, transparency. In the same line, in half the countries, translators don't get any extra remuneration for secondary uses, like paperback, ebook, audiobook, streaming services. This is closely correlated with the lack of royalties. If I go from one map to the next, you see those are the same countries, unless I'm mistaken, with the only exceptions of Austria, Croatia, and Lithuania. So this compounds the lack of proportionality of the remuneration. Last but not least, in 2/3 of countries, there is no legal contract adjustment mechanism. That is, when the original remuneration turns out to be disproportionately low compared to the subsequent revenues generated. So again, this just changed with the implementation of the DSM. Especially as the situation is actually even worse than you could figure out looking at the map, because even in those countries where such a system exists, such as Finland, France, Iceland, Poland, Spain, they are rendered mostly ineffective by, one, the fact that translators are unaware they exist, or the burden of the proof is too heavy, or the procedures are too costly, or rulings are erratic, etc., etc. So, in true fact, nowhere do translators ever get more than was provided for in the contract in the first place. So, okay, getting to my last section about transparency.
Could I just ask,
Sure.
the Norwegian case of royalties paid after a specified time?
Yes.
Can you elaborate on that briefly?
Okay. So let me see if I have.
Maybe I should say something about it, Cécile.
Sorry.
Maybe I should say something.
Oh
about
yes,
the
thank you,
Norwegian,
Hilda.
Norwegian case. So it is not really after a specified time, because a royalty only applies to audiobooks and ebooks. Or no, sorry, that's not true, because after we implemented the new contract, there will be royalties on paper books also after, I think, 5 years.
Okay.
Okay, now I was looking for the answers of members, and the respondent for Norway did not comment on that, so I could not tell you. Well, it's after 10 years or.
That's after the first period, when you sort of renew the contract. After that, there's a royalty on sales of paper.
Oh, I
books.
see. Okay. Thank you.
Thank you very much, Hilda. Oh yeah, so the most colorful picture, because that's where the picture is most mixed. The question was, do translators receive detailed and at least yearly reports? So that goes from almost always in Norway, the Netherlands, and Germany to almost never. And as I said, that there is a close correlation between the absence of royalties and the absence of reports. And until now, in 2/3 of countries, no minimal level of transparency had been defined either by law or collective bargaining with the publisher. So only in those countries in green was there an agreement. Now, of course, if I were to do this map today, I would greenlight Denmark, for instance, because they have, in these last few months, reached an agreement on transparency with the publishers. So that's one of the first positive fallouts of the DSM directive. And I know that also in Sweden, they are now in the process of negotiating such an agreement on transparency. So if I conclude with the main takeaways of the survey, we saw that everywhere, I mean, in all our countries, and in accordance with the Berne Convention, European literary translators are recognized as authors, and they enjoy more rights. Their associations do a good job of providing model contracts and codes of good practices. Yet, in most countries, the legal framework is relatively weak, and we lack collective bargaining to negotiate standard contracts, remuneration, transparency. Current situation is a far cry from the principle put forward in the directive, especially regarding remuneration, since in a majority of countries, literary translators suffer from unfair payments schedules and receive only a once and for all lump sum. So no royalties, no extra remuneration for secondary uses, regardless of the success of their work. Also, about transparency, the situation of literary translators is bad, as in 2/3 of our countries, we rarely or almost never receive reports. So yeah, the implementation of the directive is really a unique opportunity to rebalance the contractual relationship and put an end to these sweeping buyout contracts. Yeah, okay, I'll quit the sharing for the moment. And Raphael, we had we had seen a couple of very interesting questions and comments in the registration list. If you will please remind me about them.
Yes, right. As you know, we've asked in the registration survey if there's anything in particular that you're interested in. Most of the answers were indeed general, but as Cécile said, there were some interesting questions and comments. One of them coming from Sweden was this. I'll read it out. An interesting topic to discuss would be how to avoid lowering the remuneration if royalties are introduced in the contracts.
Yes, thank you. So I'll give my view, and Raphael and Hilde can complement, and then in the open mic section you might also contest or discuss. My view about that, if this is taking a publisher's point of view, like, oh, if I give you royalties, then I will lower the basic fee. In the directive, the principle is that the translator should get fair and proportionate remuneration, and these two words are very important. You're entitled to both get make a decent living with your work, and then benefit from the success whenever there is success. So it's not the one against the other. Of course, some publishers will try to do that, or tempt you into accepting lower price rates for bigger royalties. Amazon Crossing, for instance, has done that with some level of success in some countries. But definitely, as I said, royalties are a plus in my view. So they should not be exchanged against a fair basic rate. But they should be there to so that you benefit from the success of the book. If they are in those countries where they exist, they are paid after an initial period, after the basic fee has been compensated. So it's already a success, for the publisher here. So I think it's very negotiable. I can see a reaction from Elisa. How do we go about it? Oh, maybe we come back to it in the open mic moment, and we proceed with the other questions that we had noticed.
Yes, so another, and this is quite a sweeping question, which might, in theory take ages to answer because there's so much to talk about, but it's still interesting and important to mention. A question from Denmark: what can I do to improve my and my colleagues' rights and working conditions?
Oh yeah, so I like this one because it had a Canadian ring to it. Okay, well, what can I do? Instead of what can the association do for me, or what can CEATL do for me. So yes, what can the individual translator do for him or herself and for his colleagues? I think the answer is twofold. I mean, two avenues to explore. One is knowledge, and the translator who asked the question is in a good way since he's here. I think knowledge is a great power. So know the rules of the game, know the law, know the good practices, and if collectively and individually we know more than the publishers in front of us, as associations or as individual publishers, we are already in a good place to negotiate. And then the second part of my answer would be, of course, collective strength. We are stronger together. So that information we need to share among ourselves at the national and at the European level. So this is what we are doing today, and this is what our national associations do on a daily basis. I know, for instance, that in Italy they are very good at sharing information even about the rates that they get from the publishers. Maybe Elisa will want to say a word about that later. So yes, sharing information among ourselves and acting collectively, I think is the way to go. Then I also wanted to answer two comments that were made at the registration stage. I wanted to say that a lot of respondents expressed an interest in rates and better payments and remuneration, rates, royalties, taxes. So two things on that point. Maybe some of you may be wondering, well, what does transparency, what does the revocation right, what does the name on the cover, what do all these points have to do with remuneration? And I say it's all about the money, and especially the DSM directive. The starting point of the European Commission was the fact that creators were not in a position to make the best of their rights and did not get enough money for their rights. So everything in the directive, in those articles, is meant to reinforce the negotiating position of authors for them to get more money. So of course it's very visible in Article 18 for fair and proportionate remuneration, but transparency goes the same way. We need to know how our works are exploited and what revenues they generate to be able to better negotiate. And the same goes for the other provisions. So do not think that this has nothing to do with the money. And another thing, I will share my screen again. Some of you may have come with a desire to know about our rates in the different countries. So this is not a work that our working group has been doing. As I said, it's been done by the Working Conditions Working Group. They have published a survey in 2020 about those rates. As you can see, all countries, minimum, usual, maximum fee. So that will give you a general picture. You can go to our website and there's a section for surveys and you will find it very easily. So this is for rates proper in euros per 1,080 keystrokes. Now, evaluating the level of revenues of literary translators is another problem, because if you want the whole picture, you need to take into account the standards of living, you need to put in the picture the different social systems, social contributions, fiscal systems. So this is not something that that the group has done this time. It had been done within the previous survey, But at least here we have an overview of the rates, if that answers some questions that people might have come in with. And a last word about the comments that were made at the registration stage. Someone expressed an interest in the, I quote, harmonization of authors' rights throughout the European Union. Well, that's, as it happens, I know the person who wrote that, that's Jean-François from France. Jean-François is also a militant within AVTE, that's the Federation of Audiovisual Translators. And I wanted to use his remark to say that, to comment on the word harmonization and authors' rights. The DSM, another good fallout of the DSM was that it brought cooperation between all creative sectors. It brought all creators together to lobby for good provisions for the creators. That is, in all creative sectors, music, cinema, audiovisual, you name it. So in some countries like the Netherlands, all creative sectors have a long history of working together. In other countries, like in France, it was more of a surprise actually that to discover that we really were faced with the same issues, because we had this habit of working within silos. So I think it has been a great progress of these last few years that we have been networking with other creative sectors to bring everyone up across the sectors and across the countries. So now, of course, the next stage towards harmonization is more tricky, because the DSM directive states basic principles, but it leaves a lot of leeways for the national states to implement them. So now the battleground is very much national. So this is where we are trying to help member associations to make the best of the directive. Raphael, I seem to see some activity in the chat room. Do you want to voice some question, or do you think we should leave that for the open mic moment?
Well, we mostly have comments from Claudia Steinitz from the Seattle working group, who says that their working group is working on the comparison between the fees and other income and the general living costs, which you mentioned. So that's something to look forward to, because that sounds really interesting. We also had a comment from a little bit earlier from Sweden, when you were talking about types of royalties, that in Sweden, they recently negotiated a contract with a large publishing house that admits a fixed no of prolongation periods after the initial contract period, and then each prolongation period will give the translator a negotiated remuneration for that specific period. So they will see how this will work, but it's an alternative to royalties. So this sounds like something fairly similar to the Norwegian thing, more or less.
That was very fast for me. I must say, I'm not sure I got it all. Maybe we can go back to it.
Yeah, I'm sorry. I was the one who wrote this. Can
Okay.
I just explain
Yes.
very quickly, or not? Maybe not that quickly. Then it's a fixed number of no's. A fixed number of prolongation periods that we negotiated, just as a way of securing further remuneration for the translator if the contract is prolonged. So we negotiated a fixed number of such periods, and for each period the translator is given a fee or a remuneration that is calculated according to a certain way. I can't get into more details because this is we have some lost the word, but it's the secret contract, but this is the model for it. And we wanted to try this. This has just been in force for a year, so it hasn't really been used, I suppose, for anyone. But it's an interesting way to receive further remuneration, I would say. And because I also wanted to comment on this royalty possibility of royalties, because we in another negotiation that we had recently, it was the publishing house suggested, would you be interested in royalties for secondary rights? And as we know that these secondary rights, it was actually audio books, are going to be the most interesting part, but still there is no guarantee, and usually very few of the translations become audiobooks at the moment. That's the case in Sweden. We also thought that there would be such small amounts of books sold this way that it would really be it wouldn't be an interesting way for the translators. They would not receive enough money in that kind of with that kind of agreement. But this is difficult to. Do you follow me? I mean, the first. In Sweden, we use lump sum agreements for the work and for the transition of the rights for a specific period of time. But then this publishing house suggested or asked us if the translators would be interested in royalties. And at this stage, we thought it was too early to go into such a new type of agreement. We preferred lump sum agreements for specific periods of time instead, just to make sure.
How about transparency? Because in the survey, Sweden came out in red for the fact that translators almost never receive accounting sheets.
Yeah,
which
that's true.
is usually the pattern in countries where you don't have royalties.
Mm-hmm.
I believe you are negotiating now. I mean, I've been exchanging with ESA, especially yeah, is that right?
With the Publishers Association. Yes, we are discussing this according to the new rules. And they agree that they must leave, but only upon if the translator asks for it, in order to be able to assess whether the translator is can ask for more.
Exactly. Whether it is a lump sum or royalty proper, you need to have the information to assess the value of your rights. So,
yes, that's true. So we'll see about those negotiations, but we are hopeful.
Good. Anything else? We'll just maybe proceed with the last part of mine and Simina's talking, just a few ideas of how we can and are disseminating the survey and using them for lobbying. Just to say that at the European level, so we've been networking with fellow creators organizations, such so federations such as the EWC, the Writers Federation, EXA, the Federation for Musicians, FERA, the Federation for Film Directors, FSA for Screenwriters, EVA for Visual Artists, FEP, the Federation of Publishers, we've sent the survey to. So the European Federation of Publishers is adamant that they don't have a mandate from their members to discuss working conditions of literary translators at the European level. But still, we are in a dialogue with them, and nothing can stop us from sending them the information and inviting them to forward the information to their members who might be interested. Also, we shared the info with the AVTE, which I mentioned earlier, the Audiovisual Translators Federation, with international partners such as FIT, the International Federation of Translators, the Writers Guild in the US, of course with the European Commission, and a bunch of lawyers, for instance, in the CREATE group, lawyers that are very interested in monitoring the DSM directive implementation. For myself in France, I sent it to the French Ministry of Culture. They said they were very interested. All authors associations I could think of, and the media, cultural media, and got some media coverage. So that felt good. Apart from trying to get in a discussion with the Federation of Publishers, also when I said we sent it to the European Commission, we sent it to Creative Europe, that department that grants translation subsidies, European translation subsidies to publishers, and we are advocating that when publishers get European subsidies for a translation, they should respect European law, basically. So they should respect the transparency right and give accounts. So this is what we are pushing for, that those subsidies go together with stricter rules regarding the contractual relationship between those publishers and the translators. But as I said, mainly now the battle for a better implementation of the directive is at the national field. So anything we can do nationally is good, and I'll leave Simina to talk to you about what they did in Romania.
Thank you. There is it's a short story, but it's a nice one, probably. I am from ArtLit, the Romanian Association of Literary Translators. We're a small and young association, but mainly with much help from CEATL, we managed to keep informed and to try to network and use much of the information that all the working groups are coming up with. And this is one of the cases. After the Author Rights Working Group published the results of this survey last year, we also, of course, we sent it to our members and also published it on our website in its English form, as you have seen it today. But there hasn't been much feedback on it by disseminating it only online. So in September, on the International Translators Day, on the 30th of September, we decided to choose this topic as our main debate theme. So this was the topic of our meeting. It was a public meeting, open to everyone, but of course, mostly literary translators were interested in participating. And we translated this presentation into Romanian, so the slides you have seen were put into Romanian, and we used parts of the larger report that the working group had sent to complete our presentation. Of course, it was one of the things we were asking ourselves when we chose this topic was, are the Romanian literary translators going to be that much interested in such general topics as presented here, the situation at a European level? But it turns out that well, it has lots of advantages, because this presentation is a very good starting point for many talks within a translators group, let's say. Maybe first of all because contracts are in many cases a headache for our translators. They contain many abstract terms, many legal terms. Many translators don't know exactly how they apply. So always repeating them and always explaining them, things like the transparency, like separate licensing, I don't know, the licensing scope. These are things that we should always bring up and try to talk about and remind them that it's their work, and how it's going to be exploited by publishers. So this is a good way to refresh the vocabulary related to contracts, and also when as translators, it's a good thing to see how things are working in other countries, because many times when you don't have the information, it may seem like in other countries there are these mythical ideas that there are perfect systems or not. And it's good to see, as Cécile was presenting, that yes, there are certain things better regulated, but in some cases there are also disadvantages, like the royalties or the period of licensing and so on and so forth. And it's also a good base to start to open the debate within our own context here, because, for instance, the most interesting slides for our presentation in Bucharest were the ones on negotiation, on transparency, and on the exploitation reports. The exploitation reports are something new here, so we never receive them actually. we don't know how they look like, but hopefully we will. And seeing the map for the rest of the European situation is a good. It encourages us. Let's say it's a good incentive, and also for the negotiation too, because translators here are not very keen on negotiating. There are few who go ahead and discuss points in their contracts, sometimes because they don't know how, and many times because they are too shy to do it. But holding information about what all those clauses mean, it's a step forward, I think, to get them to ask questions and to start a dialogue with their publishers and between ourselves. There were several outcomes after our presentation, our public presentation, because we partnered with the literary museum here in Bucharest. That's who hosted the meeting, and they have a very good visibility here. They have a very good press database. So we were able to have our event published in several newspapers and blogs, and as a consequence to that, also one of the national broadcast radio channels here wanted to learn more and to make a short interview, short material about the European situation and how Romania is placed within this European context. This kind of report is a very rare piece of information, let's say, because statistics about translators are rather rare, and also at a European level, it's not something we find every day. So it's also good to see where you can ask for information on good practices further on for certain parts that we're interested in. So it was a good tool for also for community building, for comparing working conditions and contracts, and discussing advantages and disadvantages, because this way our association can see better what the members want and are interested in, where are their weak points, and for them it's better because they can find out more and relax a little bit. They know that they can relate to the association for help on these legal issues. By the way, in our case, we don't have a legal counselor, so we have a colleague who is and a board member who is very skilled at legal issues, and she provides a lot of expertise, but also with the help of such reports is much easier to work. So thank you. That was our little success story.
Thank you so much, Simina. I find you are doing a fantastic job with a fairly young association with little resources and in a not so easy environment in terms of your publishing industry. So it's really fantastic, the job that you've done. So I repeat, you've posted the survey, you've translated the shorter version of it. I repeat, so there's the full version and then a shorter one with just 9 maps and a conclusion. So it's easier perhaps to translate and digest and communicate. And then you've been able to discuss it, to share it, to get media coverage. So really, really good work. Thank you. Very inspirational. Well, if there are people who want to now take the mic, they just need to raise their hand for I don't know how many minutes, just a few minutes, because all of us are tired, but please feel free. So nobody wants to react? How come? So you're all so shy. Well, okay. In that case, I'll wrap it up by thanking you again for your attendance. As you've gathered, we will proceed with that second part of the survey, which I feel will also answer needs within the association. We want to help the associations and help their members, especially, as you said, regarding negotiations. So taking stock of the strengths and weaknesses of our associations, how they can share good practices, and how they can get efficient strategies for negotiating both with individual publishers and with their associations. I think that will be the strong point of our work in the next few months. Now that we have the general picture, we know what things are like now. We know where we want to go. So now is how do we do it in the member states? Well, thank you again for all the to all those who helped me organize this. Let's stay together in touch, and let's get stronger and richer together. Thank you. Bye.
Thank you.
Thank you.